A woman in Vienna tries to sign up for a mobile phone contract. €10 a month. She is turned down. Not for anything she did, but because a company she had never dealt with ran her data through a piece of software and produced a number. So she asks the one question anybody would ask: why? The answer arrives 6 years later from the European Court of Justice, and it now sits underneath every automated credit decision in Europe. The company that made the number is a credit agency, Dun & Bradstreet, Austria. In October 2019, an Austrian court ruled it had broken the law by not explaining the assessment, and that ruling became final. And then the authority whose job it was to enforce it decided the company had complied anyway, and did nothing. So 3 things by the end of this: what explainable AI is, why handing over the algorithm is not an explanation in the court's own words, and the 3 rules teams put around a scored decision. So, first principles. Explainable AI is not one technology. It is the answer to one question. Can somebody state in words a human can check why this system produced this output for this person? There are 2 roads to that. Build a model simple enough that you read the decision straight off it, which people call an interpretable model, or run a separate tool afterwards that reconstructs a reason from the outside. Most banks are on the second road. Here is the mechanism. A modern credit model is a few hundred small decision trees stacked together. Your data goes in, each tree adds a nudge, and out comes a score. Every step is right there, and it repeats. Score her again tomorrow, and you get the same path. What the model does not do is write anything down. The file holds parameters, not a record of what it decided about this one person, which is why her question is harder than it sounds. So teams reach for a tool that works the reason out afterwards. The 2 everybody uses, SHAP and Lime, hand you one number per piece of data, how far it pushed this score up or down. That is a post hoc explanation, and it is useful but less settled than the slide deck suggests. In a peer-reviewed study from 2024, across 4 datasets and 6 explanation methods, the authors found these methods often disagree about which factors drove the same decision. 2 reasonable settings can produce 2 different stories about one refusal. Here is what a smart, busy banker assumes at this point. Fine. If she wants to know, we will show her the model. Publish the formula or print the full decision path, and the duty is discharged. The court closed both of those exits in one sentence. Neither the formula nor an exhaustive description of every step counts, because neither one is concise and intelligible. In law, disclosure and transparency turn out not to be the same thing. So what does count? The test is the procedure and principles actually applied, described so she can understand which of her own data was used, in what way to reach that result. And complexity is no excuse. Hard to describe does not relieve you of the duty to describe it. Then the objection the agency ran. This is a trade secret, not a ground for refusing either. Where the controller believes the information is protected, it hands that material to the supervisory authority or the court, and they decide how much the applicant sees. The secret does not disappear, it stops being a wall. There is a second ruling underneath this one, and it settles who owes the answer. In December 2023, in a German case involving the credit bureau SUFA, the court looked at a probability value. The bureau's position was that it only supplies information, and the lender decides. The court held that establishing that value is itself automated individual decision-making, where the third party it goes to draws strongly on it, and it was concrete. An insufficient value leads, in almost all cases, to the loan being refused. You cannot park the duty to explain with a supplier. Now the case that complicates the story. In 2019, a public row broke out over a credit card after a tech entrepreneur said his wife got a credit limit 20 times smaller than his on the same finances. New York's regulator investigated nearly 400,000 applicants and found no evidence of discrimination. But read what it said next. When the regulator asked, the bank could explain the decisions of every individual who had complained. The gap was that the law required an explanation only where credit was denied, so nobody had to tell those customers anything. And how many banks have been fined anywhere for failing to explain a scored decision? So far, none. So when does this bite? 3 doors on 3 different days. The first has been open since May 2018, the right to meaningful information about the logic involved, which is what the Vienna ruling defines. The second opens on the 20th of November 2026, when the new consumer credit rules apply. If the assessment was automated, the consumer can demand human intervention, a clear and comprehensible explanation, and a review. The third is the AI Act, and this is where almost everybody stops reading. The high-risk requirements for credit scoring were pushed back to December 2027, but the article giving an affected person the right to clear and meaningful explanations sits in a different chapter, and the postponement never touched it. On paper, it applies from the 2nd of August 2026. Be careful with that, because there is a real hole in it. The right attaches to a system classified as high risk, and the provision that does the classifying is itself in the postponed chapter. So a bank can argue there is nothing to attach to before December 2027, and no authority has resolved it either way. If your compliance function has written this off until 2027, that is a defensible reading, not a settled one, and there is now somebody to argue it with. At the end of July 2026, Germany's financial regulator confirmed it holds AI market surveillance for AI used in regulated financial activity, and it named creditworthiness assessment. So, 3 rules, and none of them are technical. 1. Decide at build time, not at complaint time, whether a decision from this model can be stated in one sentence you would defend to a supervisor. If it cannot, use a model you can read. That is the argument of a 2019 paper whose title says it all. Stop explaining black box machine learning models for high-stakes decisions. 2. Log the reason when you score, not when somebody asks. The reason is derivable, not stored, so every explanation that reaches a credit file is something you computed at the time and chose to keep. 3. Put a name against the sentence, not the vendor, not the bureau, and not the model. So rewind to Vienna. €10 a month, 1 refusal, and a question that took 6 years. Run that same application under those 3 rules and almost none of it happens. She is told on the day which of her data was used and how it moved the answer. The trade secret goes to the regulator to weigh instead of becoming a wall. And there is a name against the sentence. A score is not a reason, and if your system cannot produce the reason, you do not have a decision you can defend. You have a number you are hoping nobody asks about. The free RegAI brief newsletter goes to risk, compliance, model governance, and audit people working on exactly this. Link below.